Okay, it is 5 o'clock. Shall we commence?
All right.
All right, fantastic. Well, thank you everyone for attending tonight's webinar, one of many webinars this year for AMC. We'd like to thank our sponsor, JWS, for sponsoring the event. We appreciate all our support from our vendors in helping us put on these events, both our webinars and our in-person seminars at the Arden Woods or Arden Hilton Hotel. This evening, we will be talking about lien enforcement basics with Carter Glahn. Carter is the principal at Severaid Glahn. He has 35 years of experience, a graduate of UC Davis Lincoln School of Law. Mr. Glahn is the author of AB 2273, and AB 2273 is part of Civil Code Section 2924B and Section 2924.1. Severaid Glahn has been a partner of AMC's for several decades now. We rely heavily upon their expertise and their managing of our process when it comes to collections and for liens and foreclosures. So thank you, Carter, for being with us this evening, and I'll turn it over to you and your presentation.
All right. Thank you, Tony. I'm glad to come and speak to you all here this evening. We often do get many questions with regard to this process, and so if I can hopefully unveil a bit of the mystery that everybody seems to find around this, that hopefully will be helpful to you. And as always, I will entertain questions after we conclude going through the presentation. I'll try and keep it brief. It's presented as sort of an outline to give you just a quick view of what the steps of the process are, as that seems to help people kind of get their hands around what goes on. And as you have questions, jot them down and I'll be happy to answer them when we get to the other side. All right. So let's go ahead and jump into this. As it says, this is just lien enforcement basics. And as noted, our office, not me personally, I'll have to correct Tony on that. I don't have 35 years of experience on this, as I've only been in practice about 22 years. But our office, Ron Severaid, predates me by a couple of decades. And so at this point, we've probably got over 40 years between us in doing this particular type of work. So we specialize in it, and hopefully we can provide you some good information here. So looking at the matter, the first thing to do is here's an overview of the process as it goes through in sort of chronological order. The late notices, which are given out by your management company and or association. And then when those aren't answered, a delinquency referral. So the management company refers it over to us. And of course, that has to all follow your internal policies first. And then when it gets to us, we are bound by the civil code to follow those provisions. And I'll go into each one of these sections more in depth as we go on. This is just sort of, like I said, your overview. Then when the pre-lien goes out, at this point, we often see that owners will continue to make payments and partial payments come in, and we have to deal with those. And there's also the issue of when the owner decides that they want to talk to the board or discuss the matter with the board, then we deal with that as internal dispute resolution, or IDR, or alternative dispute resolution, ADR, which the difference there being one is an informal process, the other one gets more formal as you bring in some third party or a mediator or an arbitrator if the parties are willing to foot the bill for that. Both of those are, each side pays their own way on the ADR process. Then if that isn't successful and we've gone through the pre-lien process, the next step will be a recording of a lien. So the lien will get recorded with the county in which the property resides. And then we have the next two phases that tend to crop up is once the lien is in place, we often get calls from owners and then they want to discuss payment plans. And again, there can be the IDR, ADR request if it hasn't happened previously in the last step. And same rules apply there, and I'll go into more depth on that in a bit. Then if the lien is not satisfied, you record what's called a notice of default, or NOD. And that means default of the lien. The lien gives them 30 days to pay. If within that 30 days they don't pay, then the board can authorize us to record the notice of default. The notice of default is only available to be recorded once we have met those threshold limits that are set up by the Davis-Sterling Act. There was a change back a few years ago that, of course, changed it to that you could not record or start the foreclosure process until the amount due reached $1,800 in regular assessments or reimbursements, or it was a year old. And that was put in place because the lawmakers recognized that some associations are only annuals and may only be a couple $100 per annum, in which case it would take many, many years to reach that $1,800 threshold. Meanwhile, the association would be left high and dry without the budgetary support from the assessments that are supposed to be paid. And then again, with the NOD is the IDR and ADR request that is present in each of the steps and as mandated by the civil code. So then if the notice of default, it goes for 3 months and is not satisfied and the matter is not resolved, then the association can authorize us to proceed to foreclose the lien, which then carries with it a steps of procedure as far as setting a sale date and conducting the foreclosure sale. And there are the results of that, which can be that it's sold to some third party, or that nobody bids on it and the association is deemed the winning bidder, in which case the association becomes the owner of the property. And following that, there is a period of 3 months in which the owner has, or 90 days, which the owner has to pay up everything that was owed plus the costs that had been incurred to that point and redeem the property. It's called the right of redemption. And as I said, I'll mention that more in depth later. And then with regard to some complications, bankruptcy is always an option that an owner may file, which will bring a halt to the whole process. Under the federal rules, a stay is put in place when the bankruptcy is filed, in which creditors must cease all activity with regard to securing or pursuing debts of the filing debtor. And then we follow that. We'll do filings in bankruptcy on behalf of the association. And there are rules that are surrounding that, which, again, I'll discuss in a bit. And then, as I mentioned, the redemption process, as far as the owner being able to redeem the property following the foreclosure. So that's sort of the brief bones outline of the process and the steps. So let's take a little closer look at it as we go. So late notices. This is pretty self-explanatory. The association has a policy which they will have adopted, and they have to follow that policy first before they can refer the matter out to us. Under the civil code, all assessments are late after 15 days from their due date, unless the association's CC&R state a different time period. And one of the things you have to be sure you do is that the policy has to be implemented equally and neutrally. One of the quickest ways that associations get into trouble is when they don't afford the same leniency or leeway to everybody who comes under the qualifications of the late policy. So it may seem harsh, but sticking to it and following it by the rules adopted is the best practice as far as being able to keep you in compliance with the law and with your internal policy. Now, once you've done those things and followed them, discussion with board members or among board members and with the owner in question can always take place. There's always room for dialogue to happen between the two. And then some of the notices that may be sent out by associations or their management company, things like the intent to lien. There is nothing in the civil code that requires that the association send a letter saying, okay, you're late, you haven't answered your late notices, we're going to send you to lien processing, or we are giving you the notice that we intend to file a lien. You don't have to, it's not required, but it may be a good idea, based on the idea that most of the complaints we get from owners is when they get our first letter, they say, well, we had no idea. Most of the time, this is because they just ignore letters that come from their HOA. So, the law says you have to provide notice to them, but, much like the proverbial horse, you can lead it to water, you can't necessarily make it drink. Same with the owners. You can send them all the mail you want, but you can't make them read it. So once you've done that, you've satisfied your duty as far as that goes. Okay, so late notice has gone out and there's been no response. So now the referral is going to go out to our office from the management company, or the association rather. Again, as said, Section 5650 states that their assessments are delinquent 15 days after they're levied, unless you give a longer period in the governing documents. And you have to have impartial and consistent enforcement of your delinquency policy. Excuse me. One of the things that happens is reluctance to send somebody through, and this comes in under the impartial and consistent enforcement of your policy, is that boards will feel sheepish or reticent about sending out owners just on the basis of what the policy says. But if you let balances linger and fester, then higher balances are more difficult to enforce, because the bigger that balance gets, the owner has more and more difficulty in coming to terms with it. And so, much like with things that are, small wounds, if left alone, can get big. So better to deal with it early, and hopefully the owner has the means to be able to resolve it quickly when it's early and small. So you've gone through that process. It's been referred out. Now we're moving on to the pre-lien. So under the civil code, the association has to send, or we have to send, what's called the pre-lien notice. And that's a notice that states what is due, the policy of the association with regard to what the civil code says. It's a certified letter that is sent to the owner, so we track it. We can tell when they've delivered it, when it's been refused, when it's been left not picked up. It's sent 30 days prior to a lien. It is always sent to the address of record on file with the association. So it is the owner's obligation to make sure that they keep an address to which they want to have notice sent on record with the association. In fact, there was a new civil code section that was added under the 4041, I believe, stating that the owners had to provide on an annual basis the information to the association about what their address was and various other information that was listed in that particular bill. I think it was Senate Bill 381. I can't remember. But so the owner has the obligation to keep that information up, and it's a written notice that comes via the U.S. Postal Service, because that's the only one that's the law still recognizes as far as a certified. They don't recognize UPS tracking. They don't recognize FedEx tracking. The only thing that is recognized under the law is the certified process. And it's a card that is left with the owners. We don't do the return card on all of these because it would simply be cost prohibitive. However, notice is left with the recipient that they have a certified letter, or it is noted by the carrier that it was delivered, and we can track all that. We often then will get owner calls in regard to the pre-lien notice, and often that's better for the owners as far as getting it, like I said, early before it becomes a problem. And then, there it is. SB 918 was right there in front of me. And Section 4041 was what I was talking about as far as the obligation of the owner to provide information for contact to the association. And that's one of the things we get the most discussion and most issue comes up for us when owners say, well, I just simply didn't get the notice. Many times we do pull up the certified tracking and find that it was delivered to somebody at the address, and whoever that person was failed to notify the person who can do something about it, which unfortunate, but not the association's issue. That's the owner. The owner, is the owner of a property. They hold certain obligations that they have to see to. It's not like they've bought something and they just have to sit back and let somebody else deal with it. If they want that, then they need to hire their own property manager. Now, while the pre-lien is going out, I should say, we will also ask the association for certain things. Under the civil code, the board must approve recording of the lien. And I'm sure many of you have already sat through meetings where you've gotten a list of properties that are being requested to have liens recorded, and you have to approve that. And so that has to be done in an open meeting and put in the minutes there. Now, approval to record the notice of default. As it lists here, it's done in executive session, so not in the open session. It's listed. We put our resolutions that we provide to boards, just the APN number. Sometimes you use the account number, but you're supposed to do it such that it protects the identity of the owner whose property is on that list, because that approval then goes in the minutes of the following general meeting. So it's done in executive session, but then put in the minutes of the following meeting for the general meeting. The idea there being that if someone's property were to be approved for notice of default and they had no idea the process was going on, they'd be able to read the minutes and recognize their own property and know that they had to do something. How much that actually happens, and I don't know how often people in the associations actually go through and read the minutes from the previous meeting. That's hard to say, but that's the system that the law has worked out. And that notice, that NOD approval doesn't mean, at least with our office, does not mean that you've approved foreclosure of that lien at this point. All that says is that if you reach the threshold where a notice of a default can be recorded, then you have authorized to do so. And the advantage to having this is that once we've gone through the lien process and recorded the lien and sent the notice to the owner, then being able to use this approval, because we have to notify them according to the law that the approval has been done. Once we have this approval, that's yet another tool that we can use short of going through foreclosure to get the owner to act. So moving on from the pre-lien notice. In the process, once the pre-lien's in place and while we're waiting for the lien to be recorded, partial payments may come in. In other words, an owner may see that they're delinquent, and this happens often. They will look at the total due, including the costs and interest that have accrued, and will try to contact the association directly or send payment of just the assessments, thinking this will get them out of hock. It used to be that before 2014 that you could refuse partial payments. It's the perfect tender rule under common law and under the Uniform Commercial Code, meaning that if you tell somebody that a certain debt is due, you as the creditor do not have to accept anything except full tender of the debt. It's called the perfect tender rule. However, in this case from Huntington Continental Townhomes v. Minor, which came out of Southern California, as so much of this case law does, this was originally a local ruling for an owner in an association where the court said, yeah, we think the law says that if an owner makes a payment, it has to be accepted. You cannot reject it. The association didn't like that and decided that they would appeal it in the local appellate court. And they lost there, and then decided they would appeal it to the 4th District Court of Appeals in California. and they lost there as well. So now it went from a local ruling that wouldn't necessarily apply statewide out to a statewide ruling that now we are unable to reject partial payments, which means owners can, and sometimes do, start making these partial payments just enough to keep the property from making that threshold amount due and keeping it out of notice of default, and therefore keeping it going in limbo for as long as they can. Eventually that tends to be resolved by the 1 year limitation, but it does present problems in the meantime. So, but that's something that we deal with here. When those payments come in, you have to apply it to the account, and it has to be applied to the assessments first. And then it can be applied to other costs and fees, and can be applied to late charges and interest in the last. What we do is send out a notice when we receive that saying, yes, we've received this payment. It's been posted to the account, and that the remaining balance due is X. And it doesn't necessarily stop the lien process or foreclosure just because they paid something. So you could proceed if the circumstances are right. But it is an issue that crops up, and there are owners who will be so upset about being sent through the process that they will pay just the assessments, which then keeps the property from going through foreclosure for some time, and draws it out, and can lead to issues for the association in trying to resolve these really old balances. But again, that's something we deal with, and it doesn't happen with most files resolve quickly, particularly by the lien phase. But there's probably a good 1 in 10, 2 in 10 that actually end up having issues like this and get drawn out for some time. And then there are ones that are extreme cases. So, dealing after the pre-lien, the 30 days has elapsed, and now you can record what's called the notice of claim of lien. The claim of lien is 30 days after pre-lien. So you've given them 30 days notice, basically saying, if you don't resolve this, we're going to go record a lien. It's recorded with the county. Notice must be sent to the owner within 10 days of recording in order for this to be valid and for you to later be able to foreclose on it. If it is found that this 10-day window was missed, then you got to go back to the beginning and start all over. You got to give them the notice of pre-lien, then you got to go through the lien process again. And there have been court cases about that as well. So the notice within 10 days of recording, that's something we carry out. We generally don't have a problem with that, except we had one Contra Costa County seemed to like to record things and then hang on to them, and then would send them to us with just a couple days left, which often caused a scramble on our end. So the owner gets notice of the lien once it's recorded, and law mandates we have to send it to them. Now, it also includes the amounts that accrue after the lien is recorded. By the wording of the lien, we state that the amounts due and after occurring amounts. So it continues to grow, but the lien, once in place, protects the association. You've got a marker in there in the process, and it's recorded in the county, so anybody who looks at the property will find that lien. Now, two different types of processes that can happen on this, and there are two different schools of thought on these liens with regard to regular assessments and what we call special individual assessments. Some of you will call them fines. I avoid using the term fines because the law doesn't ever use that term. The law uses the term monetary penalties, or special individual assessments is listed in much of the case law. So with regular assessments, we can use this typical trustee foreclosure process, which is you record the lien, then the NOD comes, then you can have the trustee record the notice of sale and go through the public auction through that process. That's the same process the banks can use. However, if you record a lien for the CC&R violations or for special individual assessments, You may only foreclose that through a judicial process, which means you have to file a court case and foreclose your lien through the court. Now, there are practitioners out there that will argue that you cannot record liens for special individual assessments. And I've talked to one of the authors of a lot of the law on this, Adrian Adams, and some of you may know him from Adam Sterling and from the website that provides you all that good information about the Davis-Sterling Act. My position is that the law doesn't say that. The law says that liens that are recorded for such items cannot be foreclosed non-judicially. They would have to go through judicial foreclosure. So it's a qualification. So liens for CC&R violations can be recorded, despite what some people will say. The law does not prohibit them. It just qualifies how they may be foreclosed. So, and that is often more a question of getting that listing of what's owed for those violations on record, so that if the property is, often what happens is those get paid when someone refinances or the property is sold, because the lien is found and it has to be satisfied in order to pass good title. So it gets paid at that point. But again, the idea behind the violations is not so much to collect the money as it is to gain compliance. And so we often are using those liens for properties that are out of compliance to make the owner take action to come into compliance. And if you end up waiving a lot of them, it doesn't really matter, because they haven't figured into your budget in any way, and nor should they. So then the next thing we do, we call it our pre-NOD notice. There's no legal requirement for this, but it does seem to, if we haven't gotten response on the lien and the lien letter, we send the pre-notice of default, which states that if you don't act, the board will move to foreclose. We find that we get a lot of response from this particular letter. It seems to be that and part of it is served upon anybody who lives at the property. So they'll get a process server come and hand them the notice stating your association wants your attention, basically. We'll get a lot of response from that. Again, there's no requirement under the law that it be done, but such notice has to be given in this manner if it is done. There we are. Now, once we get to that stage where you've got the lien recorded and you've got you're waiting on going possibly to NOD, you've got the possibility for internal dispute resolution or alternative dispute resolution requests to show up. If they're requested by the owner, the association has to participate in this. The same is not true in the opposite. If the association asks for the owner to come in for IDR, ADR, the owner doesn't have to. It's not required of them. The association has 30 days to respond to the request. And if there is no response by the association within 30 days, then it is deemed to have been rejected. And the owner, of course, will make great hay of that later if they are going through process in fighting the matter. Once it is settled that all the parties agree that yes, there's been a request for ADR, then you've got 90 days, or it should be completed within 90 days of that determination. So you've got 3 months to work out a time to get together and discuss it. Now, if such a request comes in at the pre-lien stage, you have to complete this before the lien can be recorded. And that's under the meet and confer process here on the right. Under the meet and confer process, the owner meets with the board, or if there is no meeting within 45 days of the request, because sometimes boards will only meet quarterly, then they can designate a representative or a committee of the board to meet with the owner to satisfy the meet and confer request. And then you have 45 days to complete it once again that it's established that there's a meet and confer that's going to happen. typically what goes on there is that it's supposed to be ostensibly for the discussion about payment plans. And much of the time it's the owner saying, well, I don't deserve to have this happening to me, and I shouldn't be charged with this or that, and so I only want to pay this. The board will then, of course, negotiate with the owner and so forth. Back and forth is supposed to happen in the meet and confer. And most of the time, the result of such meetings is a payment plan. And as I said, this has to be done and completed before a lien can be recorded if this is going on at the pre-lien stage. So meet and confer, if the owner requests it, stops the lien process basically for 45 days in order for the meet and confer to be completed. And so I know it seems frustrating. A lot of boards say, well, wait a minute, we sent this through for collection or lien enforcement. Why are we having to do all this with the owner before we get our lien in place? Well, it's because the provisions of the law require it. And so one thing you want to make sure you do is you follow all the steps, because the remedy under the law for the owner when an association does not follow a step is the association must start from square one again. So you always want to make sure you're following your process. All right, so moving on to the notice of default. So as I said, the notice of default is the first step to foreclosure. Lien recording is not foreclosure. We get many calls from owners saying, you're foreclosing my house, when they've gotten our lien letter. We have to inform them, no foreclosure is pending or in process. That's just a lien. Before you can go to the notice of default, it must again be the $1,800 in regular assessments or reimbursements that are due, or 1 year delinquent. So small amounts can sit for a long time. The elect to foreclose notice, that vote by the board to authorize notice of default recording, must be served on the owner, and has to be served in person if they live at the property. It can be served by mail if they're an offsite owner. And it just simply notifies the owner saying, hey, the board has voted to foreclose. Doesn't say they are foreclosing, it just says they've voted to foreclose if it should come to that. Now, that's not the end process for authorizing notice of default. We use an additional step in there, which is once the notice of default has been, or once we've reached the threshold and the notice of default can be recorded, we will come back to the board again and say, all right, you've met all the criteria. You're at the stage where the notice of default can be recorded. Here's where the property stands. These are the costs involved. Do you wish to proceed? And the board can determine then what they want to do. Now, costs on this, we utilize a third-party trustee for this. And part of our philosophy for that is that, one, we're not trustees in the business of auctioning property. There are professionals that do that. And so we'll leave it to them to do that particular part of it. And excuse me, we feel that this also eliminates a possible incentive of a collection agent to want to push through to notice of default, because they'll collect the trustees' fees that are listed under the law for doing that process. So we utilize a third-party professional to do it and keep it that way so that there's separation between our office that's conducting the matter and the trustee that is going to be doing the actual notice of default work. The costs involved then are that upfront, it's usually between $2,500 and $2,800 to do your notice of default, depending upon what the trustee has to do, because that's a process in itself, much like getting ready to sell a house and going into contract. They have to secure a trustee sale guarantee, which is an insurance policy on the sale. They have to do particular background, delve into the title, verify that, etc. So there are things they have to do. So at the stage that the board authorizes us to go ahead and record the notice of default, we will also invoice the association for a deposit that'll match what the cost will be for the notice of default to go forward. And again, at this phase, you've got IDR and ADR requests that can come in. Again, same thing. If requested by the owner, you have to participate, 30 days to respond, 90 days to complete, and it halts the foreclosure while the parties do this meeting. And at this stage, this is typically where we'll find that an owner may consider filing bankruptcy. If they don't have the funds to forestall the foreclosure process and get the property out of delinquency, they can file bankruptcy. And that will put into effect a complete stay of all activity by creditors while the bankruptcy process completes. If it is a Chapter 13 bankruptcy, then the owner will have to set up a plan, and all creditors will be notified to put their claims in, and the court will set up some sort of payment schedule whereby the creditors get paid based on what they've put into their claims. One of the other things, though, that must happen during the bankruptcy proceeding, I'm not sure if I have this later on, but the owner, from the point of filing a bankruptcy, is responsible for continuing to pay the monthly regular assessment from that date forward. Many attorneys who handle bankruptcy and many owners don't realize this. It was a revision that came out of a rework of the bankruptcy code, I believe back in 2008 or 9. And it's section 523A16 that specifically states that ongoing obligations such as association dues must be continued to be paid from the date of the filing. And so many owners will have a rude awakening where they've sat for 48 months while their bankruptcy has been going on, and they haven't bothered to continue to pay the regular assessment. Now, once we have bankruptcy in place, and we will file the claim on behalf of the association, provided we get notification of it in time for claim filing and get that in place. We also have letters that we send to counsel for the owners, letting them know that they have this ongoing obligation. As I said, I think I talked about it a little bit more at the end here with possible complications that come up. So if the ADR, IDR process doesn't happen with regard to the notice of default, and it's been 3 months since the NOD was recorded, then the association can authorize recording a notice of sale. Now, the notice of sale is another document that goes in the record, states that the association is declaring the property defaulted, and it will set a sale date, and it gives a date in the future, approximately 3 weeks, that will then where the auction will be held. Now, that auction may not necessarily be held on that date specified, and this notice of sale can be in the record for up to 364 days. After a year, and I don't know anyone that doesn't, most trustees will state that the notice of sale is stale, and they will want to re-record that notice. It doesn't mean just going back to the beginning of the process. It just restarts that 3-week notice process. And then that new notice of sale would be good for another 364 days. The costs of going to the notice of sale, again, entails several steps, but it's another $1,500 approximately on top of the original funds that were put up for the notice of default. So all told, depending upon how complex the issue is, the foreclosure costs for the association could be between $3,500 and $47,000, or let's call it $5,000, in order to get to an auction. So that notice of sale will set the trustee sale date approximately 3 weeks after the notice of sale is published, and publication happens in a newspaper of general circulation. So it's a public notice, much like the NOD. The NOD is published for 3 consecutive months. The notice of sale is published for 3 consecutive weeks, so that everybody's aware that there's going to be this auction of the property. And at the sale, the amount that will be set for the opening bid is the amount that is owed to the association. And something I should add here is that the trustee will add their costs to it as well. So if someone comes up and pays the amount, then the association will get paid all it's owed plus its costs. So you're not out of pocket. You'll see those costs back. But it is money that's paid up front until you can actually get it foreclosed. Now, at the sale, it could be purchased by a third party, which best case scenario for the association. Some third party comes in, buys it at auction, puts the money into escrow, and the association has the money secured and will get paid out what it's owed. However, if there are no bids, in other words, perhaps the property has a huge first mortgage on it, then the property will revert to the association, which means the association becomes the owner because your opening bid was the only bid that was put into the auction. So the association is deemed to have won the auction. And that's an issue that isn't so much a problem anymore. Property values have buoyed to the point where you don't have a lot of them that are upside down. Back a few years ago during the mortgage crisis, when most properties were way upside down as far as what their loans were to value, foreclosure was just not always a good option. The association would end up with the property and still not be able to sell it. The problem here is that almost everybody's CC&Rs have a clause in them called the Protection of Mortgages Clause, which means that the association's lien is automatically inferior to whichever bank holds that first interest or mortgage on the property. So even though you can go through this foreclosure process and sell the property, the bank will still have its claim under its mortgage on the property, and they could always go and foreclose out from under you. They can pursue their process and take the property, even though you've gone through all of this and had somebody bid on it. Now, at the conclusion of this, the winning bidder does not get a deed. What they get is called a certificate of sale. The certificate of sale says, yes, this was sold at auction. However, it's going to be subject to the right of redemption, which I mentioned earlier. That the owner has certain rights following the auction, but the association or the winning bidder also has rights. So if there's a tenant in the property and the association, it reverts the association can inform the tenant that any rent that has to be paid is now to be paid to the association. So there is the possibility that even if you've reverted to the association, if there's a renter in the property, you might be able to recoup all that you are owed by collecting that rent. Some people will ask, well, what about rent skimming? Because they've heard that term. Well, one of the things about rent skimming is that the person who is supposed to be paid, in other words, if the bank is sitting there saying, well, wait a minute, we're supposed to get our mortgage payment, so the rents that you've collected, you need to be paying to us. The bank has to come forward and make that claim. And then in the ensuing process, will also generally have to explain why it is they are not pursuing their remedy to foreclose on the property. So a bank, courts are not happy when people sit on their rights. And so if a bank knows that foreclosures happen, and they've been notified of this by the association, if the bank knows the foreclosures happen but does nothing because they don't want to foreclose on the property and become an owner and become obligated to all those rules under the CC&Rs, then that's not good reason. And courts generally will look disfavorably upon that. So my advice to associations is, in these situations, collect all those rents, escrow them, keep them in a separate, somehow, segregate them, keep them in a separate account. So if anything does happen and eventually somebody comes forward and says, wait, we're owed all those, you've at least got those set. So you can say, okay, fine, here they are. But as I said, the likelihood that the bank's going to come forward and complain about rent skimming is an uncomfortable conversation they have to then have with the court about why they didn't go forward with their own foreclosure. So I have yet to see it happen, and I've seen many associations that have collected rents or in a vacant property have set it up and rented it out long before the bank ever makes any move to foreclose on anything, and the banks never come knocking looking for missed mortgage payments. They're just happy to foreclose, get it off their books, sell it, and take what they can for it. So as I mentioned, the right of redemption, and this came in with that same change that happened as far as the $1,800 rule. The owner has 90 days to redeem the property after the foreclosure. And they have to pay all the amounts due plus costs of foreclosure. The winning bidder does not get possession of the property during the redemption period. The foreclosed owner could be staying in the property for that 90 days. They don't have to leave. However, if there's problems with the property, the new owner does have the right to secure the property. So even though the new owner isn't specifically allowed to possess and go on the property, you can go in and secure it, particularly in the case of vacant property where you're having problems, often with perhaps squatters, and that issue. You have the right to secure it and make sure that no further damage is coming to it during this period. Now, once the redemption period is concluded, then the final trustee's deed upon sale is issued. The trustee will contact us and say, look, we've gotten no redemption payments. They'll ask us if we have received any. When we say no, they say, okay, we will issue the final trustee's deed upon sale. And at that point, that's just like a regular grant deed. You have the right to possess the property once that has concluded. Now, something that I need to update here with this is that also following the sale, they now have a new law that states that a bona fide bidder may come in after the foreclosure auction and make a claim stating that they wish to bid. So in other words, if it goes through auction, nobody bids at it, somebody who comes forward says, I wish to bid on the property and am willing to pay, and they have to tender up what it is they're willing to pay. The amount that was due at the auction, plus costs. And they also have to show that they are a bona fide purchaser who's going to occupy the property. This is the trip up for a lot of people who thought they might be able to swoop in after a foreclosure here and pick up properties, is that the requirement is that they must reside in the property in order for them to be considered a bona fide bidder. And if it's found that and I believe it's a 6-month period following the transfer of the title, if they are not in the property, then the property can be dispossessed of it as a remedy, and it can be taken back by the court for someone who finds that. But that just came in last year and is just sort of getting going, and we haven't seen yet. I don't think we've had. I've had one case, I believe, down in Stockton, where we actually had a bona fide bidder who made the statement within the time frame. It has to be 15 days after the foreclosure completes, but they never put up the money. So that's the other problem for them, is that they must, if they state they're a bona fide bidder after the fact, they must then pay the money within 45 days of the auction. So, as I mentioned, one of the things that can throw a wrench into the works is bankruptcy. And just a quick word about that here, so you've kind of got an idea of what that all entails. Some of the terms that are thrown out for bankruptcy are the date that they file bankruptcy is called the petition date. And at that point, what should happen in an accounting sense is that the account should be split. As I mentioned, they have an obligation to pay those amounts that come due after the petition date. And so you should have a pre-petition account and a post-petition account. So all the amounts that are before the petition date are now become uncollectible under the stay. All those that are after accrue. You can't take any action. The stay is still in effect. You can't take any action, but you can continue to accrue it. And you can continue to update the owner as to the amount. You can't say, we're going to take action, you're late, you're delinquent. Just say, here's a statement of your account from the date you filed bankruptcy forward. Nothing more, nothing less. Just keeps them apprised of what's going on. The Chapter 13 versus Chapter 7, as I mentioned, Chapter 13 is a payment plan to pay back creditors. And that's on a schedule that the court will work out based upon the application that the debtor makes. Chapter 7 is what people think of when you think declaring bankruptcy and you just give everything up. It's called liquidation, in which case you basically tell the bankruptcy court, I've got all these debts. I don't have enough money to pay it. I'm giving up. Uh, the owner is given certain amounts that they're allowed to claim as exempt because they can homestead and claim a certain amount of their property exempt because they have to be allowed to live someplace. And other factors that enter into the Chapter 7. They also have to meet a means test where they have to show the court that they can't afford to pay off their debts. I have several of these Chapter 7s that have converted to Chapter 13 because they can't show that they don't make any money. Their means are too great, and so the court will say, no, you can pay your creditors back. You just have to work it out. So that's their difference. Chapter 13 is payment plan. Chapter 7 is liquidation, sell it all off. And as I mentioned, the stay of actions, that's what gets put in place, stops all creditors, stops all activity. So you can't come after the assets that are being used to work out the bankruptcy provisions. No collection activity during the case. And as I said, you can update the account statuses, but no late notices or warning letters about how late they are and what's going to happen to them. The lien does survive the bankruptcy. And once the bankruptcy is concluded, and it could be as little as 36 months, maybe as many as 60 months, depending upon what happens, the association can move to just foreclose its security interest. Now, the debt, if the owner has been discharged into bankruptcy, the debt is gone. You can't say we're foreclosing for the debt. All you're doing is foreclosing your security interest because the security interest remains. So that claim of lien that you have on the property is just a security interest, and all you're doing is saying we're executing on our security interest. You're not trying to collect the debt, you're just foreclosing your interest. And the lien also still appears in the county records. So it creates a title issue even after bankruptcy. And we often end up using that as negotiation process to get a release and some payment out of the process if the owner or whoever ends up with the property is trying to sell it following the bankruptcy. In order to deal with it, the association amounts are rarely such that it makes economic sense to fight it very hard, and it is easier just to take care of it in the escrow process. So some of the other terms you'll hear, discharge, dismissal, and termination. So remember, a discharge is what you want in bankruptcy. You want the court to discharge or wipe out your debts. Dismissal is what you want to avoid, which means the court's going to dismiss your case and say, you don't get any help from us. And that happens when owners don't make or debtors don't make payments, or they don't file the proper paperwork or do other things that get them in trouble with the court. And then termination, and that's when the case is all done. The court finishes up the payment plan or finishes the liquidation of the properties and so forth. Then they will terminate the bankruptcy, and that is when the stay is actually lifted. So the case is all done. You have to wait for the termination before you can then come back to the owner and say, okay, you took care of this in your Chapter 13, but you failed to make your regular monthly assessment payments while you were going through that process, and now you owe 5 years of assessments that you haven't paid, which is, like I said, often a rude awakening for many owners. But you have to wait for termination, which is the final declaration from the court that the case is closed, and that lifts the stay. Now, there are some processes that you could go through. You can go in and request a relief from stay if in the process you say, look, the property is of no help to the bankruptcy estate, and we're just getting harmed by the fact that he's not paying his regular assessments. He owes a lot of money for it. There's nobody else that's being paid out of that fund. Please let us go ahead and foreclose. And that's called a relief from stay action. That's outside of the lien process, obviously, and carries the costs involved in going through a federal litigation process to get that. but there are means to do that if the bankruptcy seems to be dragging on and the owner seems to be somehow dodging what their obligations are. Rarely happens. Even banks rarely go for the relief from stay action because you do have, it's a high bar to meet that shows that you're being harmed by the fact you don't get to foreclose your interest here. So I think that's about all I'll say about bankruptcy then. So that's kind of that's a quick overview. I mean, there are facets and parts to this that obviously I'm sure there are probably many questions that arise from this, but that kind of gives you a fast and quick overview of what the steps in the process are. As I say, we specialize in the non-judicial lien enforcement. It's 95% of what we do, but we also do some document revision, and we've been called in as mediators for associations we don't work with otherwise to deal with problems. But you can contact us there, or again through your manager at AMC. They're wonderful about getting in touch with us when boards have questions. So I'll turn it back over to Barbara then and see if anybody who's participating has any questions.
I haven't seen anything in chat. If there's any board members present that have a question, I guess put up your hand or type it in chat so I can have, here we go, Michael. Where'd you go, Michael? I just saw you. So I can give you your right to, there we go. Allow to talk. There you go, Michael. You can ask your question. Oh, ask to unmute.
Yes, when you're listing earlier in the newspaper, the listing for the 90 days.
Yeah.
There's not many newspapers out there to list stuff in anymore. They're either online or non-existent.
Yeah, that's a matter that the trustee handles. I haven't been involved in that. I know that there were several banks for foreclosure, because they have to do the same thing. There are certain publications that are considered of general circulation enough that they qualify. They tend to be smaller. They tend to be specialized real estate newspapers or messages. But that's something that, we've recognized that for some time, but it's been an issue that the trustees have handled, because the banks have to go through the same thing for their own foreclosure. So there's a way to get it done. They're not putting notice out in the Sacramento Bee or the Elk Grove Citizen because that actually would probably cost too much for them to notice it for 3 months in the paper.
All right, Deborah, ask to unmute. Are you there, Deb? There you go. Okay.
Yeah. Can you hear me?
Yes.
Yep.
Okay. My question is this: in regards to once a nod has been recorded and the homeowner has been notified that foreclosure is intended unless they can come or accept a payment plan. Once we accept the payment plan with the homeowner, if that homeowner defaults on their payment plan, do we then have to set aside money and start this process all over again?
No, if they default on the payment plan, and the verbiage from I thought I had a slide on this, maybe I don't. We require written payment plans. That's just a given. The written payment plan does specify that if the owner defaults on it, then the association starts the process from wherever they left off when the payment plan went into place, with credit given for the payments made, obviously. But if you had a net notice of default recorded and the owner defaults under the payment agreement, then you're right back there with your notice of default, and you continue from the spot where you were.
Okay. And then I have another question, if I can ask another question.
Go ahead.
And I'm just going to give you a scenario that actually really happened to us. So there was 3 people we were going to file foreclosure against, and we had to come out with $10,500 money out of our till. to start the process. Two of the people paid in full, so that was great. So my question is, and one of them we accepted payment from. So my question is that $10,500 that we gave to your office to hold in the till to start the process, does our community get any of that $10,500 back?
Yeah, that gets recouped. That should be recouped in the payment plan process. If it, whatever was spent up to the point of recording the NOD, that's owed by that delinquent owner. Any balance that is left over then is refunded to the association. If none of it was used, then it's all refunded to the association once the matter is concluded.
Okay.
Can I
Okay.
interrupt, Deb? Carter, I
Sure.
heard it went to the third-party trustee. So is that
Third-party
recouped
trustee.
from the third-party trustee, even though it goes to you and you give it to the third-party trustee? I think that's the question Deb was asking.
Right. That's one of the costs that is,
So it's still recouped through the,
it's still recouped through repayment
Okay.
by the delinquent owner.
okay. So
Yeah, so to be clear, again, two of the homeowners paid in full. They came in there and gave full to your office, whether it was credit card or whether it's by check, whatever, they
Mhm.
paid in full. So mind you, two of them were included in that 10,500 that we had to put there with your office to start the process to get them to pay us.
Right.
to let
And the
them know.
amount,
Okay.
the amount that those owners would have paid to resolve their process would have included any costs that had been already laid out of that 10,000
Okay.
for
Okay.
the notice of default. So there would be there's a disbursement summary that is sent to accounting showing
Right.
where everything is supposed to be applied to. And
Right.
that amount is included in the amount they would have had to have paid off.
Okay.
And then if out of the 20, if you had put up 3,500 and 2,800 had been used for the notice of default to the trustee, then that amount is included in the balance that they owed and had to pay. And then the balance left over of the $700 would be then reimbursed would be kicked back from the trust account back to the association.
Okay. And then one last question, and I
Yeah.
apologize because I was thinking that this class was going to start a little bit later, so I had to call in while I was driving. It's probably about 15 minutes late. But anyway, the last thing that I want to ask is the whole process of going, because it looks like there was a lot of steps that you had covered so the homeowner seems to get a lot of time to decide whether they're going to pay or leave or whatever they're going to do. The time and process, how long is it before this foreclosure, if you're going to have to foreclose before you get to court? Seems like it's a long period. Is it 6 months to a year?
Well, it depends on how long it takes to reach your threshold to be able to record a notice of default. In other words, that $1,800 in regular assessments or reimbursements due, or 1 year length of time on a delinquent amount if it's under that 1,800. So once you've reached that, so it can be as little as 60 days from pre-lien notice to being able to say we're ready to file a notice of default.
Okay.
Now, but being able to file that notice of default, if they don't meet the criteria under the law for the amount or the time of delinquency, then you have to wait until you reach that. So if it's an amount that's small enough that you're not going to hit the $1,800 within that year, then it's going to be another 10 months from the end of or however long before you've got a debt that's a year old. So it can, and if you've got enough of an amount at the time that the process starts and you keep everything really to the timelines,
right,
then potentially, you could be looking at 210 days between pre-lien and foreclosure auction.
wow. And then if they file bankruptcy, there's a chapter 10 or chapter 13.
Chap-
Chapter
Chapter 13 or Chapter 7 typically.
Chapter 7. So if they file a Chapter 7, all of the money that they owe us, whether they have been owing us for 5, 10 years, a Chapter 13 can wipe away their whole amount of money, all those years. They walk away clean without paying us anything if they
Yep.
file bankruptcy and they keep their house.
Well, it depends upon whether or not they can keep the house. I think the homestead exemption is 150,000 now is what you can reserve out of a property, which isn't enough. It used to be that was enough to help to allow you to keep the house. But what typically happens is the bank, who's going to be almost the biggest note holder in the whole process, and however
Right.
much they owe, the bank is going to be allowed to liquidate the property. The owner is allowed to reserve $150,000 out of whatever proceeds come out of liquidation of their assets.
Right.
And they get that. So they go away with their 150K. The bank takes the property and whatever proceeds it gets from the sale. All junior creditors after that, unfortunately, are going to be left with nothing, depending upon what the circumstances are. But yeah, that's the reality of a Chapter 7 bankruptcy, is that somebody can owe a lot of money to the creditors.
Yeah.
And they can but that's the idea behind the bankruptcy, is that it's supposed to allow them a fresh start. Part of the issue has become that having bankruptcy on your record is no longer the stigma or the block to being able to do things that it once was. It's become so common that people no longer look upon it as an issue that is going to, really stop them from doing what they need to do. And in fact, some creditors look at that, go, well, wait a minute, this person's actually a really good credit risk now because they don't have any debts. So,
And they can't do it again for 7 years, right?
Yeah.
And the money that the association puts up to even do a foreclosure when they file bankruptcy, we're also at a loss for recouping those costs.
Yeah, unfortunately, the bankruptcy really wipes a lot of people out.
Okay. Well, thank you for that. Great class. It's good information to know.
Well, that's hopefully it'll answer your questions and won't create too many more.
It does. Thank you.
Do
No
any of
problem.
the other board members have their hand up besides Michael and Deborah? Deborah, Michael. I have a question. You do have a slide, Carter, for the payment plan. And I know it's always in writing and you've got that, if they default, they get, what does it mean by priority of payment issues on your slide? At the bottom of everything, you got default association patient picks up right where it left off, then it says priority of payment issues.
Right. So often associations will have to, it rankles them, but when payments come in, like I said, they have to be applied to that oldest outstanding assessment balance first, and then it can be applied to other costs. So even when bankruptcy payments come in from the trustee, those payments have to be applied to the outstanding assessment first. And what often happens in bankruptcy is a process called a cram down, where you may suppose you put in a claim for $7,500 and the bankruptcy court comes back and says, yeah, well, you're only going to get $3,750 out of that $7,500 claim, because that's what your claim is worth, in order to give everybody a fair shake at getting something back. So now when you get those payments from the bankruptcy trustee, you have to apply them to your outstanding assessments, and you may not be able to apply them to your costs that you're out of pocket.
Got it.
Yeah, quick question.
Sure.
There's no mortgage involved. It's an old property that's been paid off. How does that affect?
In which, as far as the foreclosure process?
Yes.
Well, if the property's free and clear, then the likelihood is that you go through foreclosure, you're going to find a third party is going to come in and take it. Because if you got a property that, is a single family home, and suppose it's worth 300,000, and the association is typically foreclosing for much less than that, and so there may be some bid up at the auction, but you, the association, you're in the enviable position of, you're going to get your debt paid in full plus your costs. and some third party is going to buy it and become a performing owner for you. So you get two problems solved with one move. The not having the mortgage for them to worry about on it tends to bring in the third party bidders quite readily.
Yeah.
Thank you.
Anybody else? Any other board members with questions for Carter? I didn't have a third party on my only foreclosure. We got to turn around and sell it, but we did get more on what the association was owed when they put it out for sale.
Yeah, and there is the issue that you do that, and some people have raised the question of, but you're a not-for-profit organization. Right. So what do you do with if you're only owed, say, $25,000 and you turn around and sell the property for $350,000? What are you supposed to do with that extra money? That's a lot of profit for a nonprofit to have pulled in.
Correct. They have to pay taxes on it. I don't think they got that much though, because it was right after the housing crashed.
Yeah.
So, and it went and paid all their costs, what they were out, and then it went in, what little bit left, I think they put it into reserves, to be honest with you. Because they were underfunded anyway. So. Yeah,
I'm sure there are ways to work it out, but it's just it's a nice problem to have, actually.
Exactly. So do we have any other questions for Carter? All right. So this is recorded and it will be going up on the website. I do have a copy of the PowerPoint. So if board members wanted a copy, I'm not sure if they put it on the website or not, but I can send you a copy of it. If you send a request to customer service or anything like that, I can email it to you. And then the whole presentation is recorded, and in about a week or so, it will be up on our website, and you can go back and listen to it and rehear what Carter said if you missed something or any other questions.
Quick question, Barbara.
Yes, ma'am.
You were saying you had something you could email us if we requested it.
I have a copy of his PowerPoint. Yes, I have a PDF copy of his PowerPoint. Yes.
Okay. Yes, and I could just email customer service to request that?
And they'll ask, and I'll make sure they have access to send it up. Yes.
I have another question to ask.
Okay.
Is there any way possible that you can post it up or upload it into the board area of Appfolio? So other board members can look at it?
That's the techie lady's job, but I'll talk to him about it. Sure.
Okay.
Yeah.
It would be nice. It would be nice to have it for other board members that didn't attend the class.
Well, no, yeah, I get it. And I think that's why they put it on the website with the copy of with the whole presentation of the webinar. But
okay.
But I'll ask them if they can put it on your portal.
Yeah, that would be great. I can look at it, or I can also email you, but it's good to have to go through and see the steps, because it's quite a little bit, it's not as easy as you think it is. You know what I mean? They get a lot of leeway, so it's best to understand what all those leeways are.
It's their home, and they're trying to help California keep their homes. But you can, if you work through a collection, you can get a payment plan and protect yourself and still get your money. It just might take you a while.
Right. Which is understandable.
Yeah, and that's one of the things that I often counsel with boards is that this is not a quick process. You have to be patient, and the advantage the association has is that you can play the long game.
Yeah, because you're here longer than they are.
Yep.
Well, the other side of that is that when a board has projects that they're trying to complete, and you have people in here who are not paying their fair share, and you have, listen, nothing stays the same cost. You got the management company, they want their raise, and the gardeners, they want their raise, and private security wants their raise, and so everybody wants to get a raise, and it's kind of unfair for those who pay to pay all of the stuff, and then the people who are living here not paying. It's just not right, but it is what it is. So
that's why it's nice to have a payment plan. It usually works better. So
that way.
Yeah.
That way you feel like they're paying part in.
Correct. And if you when you look at his PowerPoint, it's written and you keep it on a short time, they pay current plus, you get your money and they're still held accountable. So it does help you with your needs.
Okay, well, thank you.
I see another hand go up. Richard. Ann. Hi, Ann. You got a question, hon? Hi. Do you know how to unmute, Ann?
I'm sorry, am I muted? Am I unmuted now?
Muted now, hon. Yes,
Okay, sorry, apologize.
no problem.
What happens if you have a resident and owner who has a repeat performance of foreclosure? We go through the entire process and foreclose. This has now happened in my experience twice since I've been living here. With a particular owner who has foreclosed once, purchased back her property, and now has foreclosed a second time, purchased it back. And I feel certain that is not going to be, this might be a history lesson that we're going to repeat again. She just tends to be at least difficult.
Yeah, unfortunately, the law is such that, she has that right to redeem after the foreclosure, that 90-day redemption period. And if she does, then she does. I mean, ostensibly, she pays all those costs included in those amounts that she redeems at. You're getting, provided, unless it's been waived in some way as far as interest and late charges. And I never counsel waiving your costs, because out-of-pocket costs are real effects to your bottom line budget. But if she goes through that process and pays all these costs again and again, unfortunately, there's no mechanism that's going to come in and say, no, you're a serial foreclosure or forecloser. You can't redeem your property. It's written into the law. She has that 90-day right. So if she wants to keep paying all those costs on top of her regular assessments, then it seems kind of silly, because obviously she's got the means to just, pay the regular assessment as you go, get it set up on, auto pay, so you don't have to. But yeah, there's nothing in the law that says that you can refuse to allow her to redeem.
Thank you very much. Doesn't make me happy, but thank you.
Yeah.
Do we have any other questions for Carter? Okay. Doesn't look like it. Well, I'd like to thank everybody for attending. Carter, truly appreciate you. I think it's the second time I've heard you present on the subject, and it's one of the biggest questions most board members have, and I do appreciate it.
Yeah, no problem. It's, I mean, I find I work with it day in and day out, so it's kind of easy for me to spout off about it. But I understand that if this is not your daily life, then it can be a bit labyrinthian and sort of confusing.
And they get frustrated because it does impact their budgets and so forth. But
Oh yeah, I mean, that's the bottom line here, is that, we're trying to help the association fill a hole in their budget, because they don't have the wiggle room to be able to say, well, we've got extra money here or there to use on this. You're not supposed to have it. It's supposed to be a zero-sum game for you each year, and that's why the budget needs to work the way it works.
exactly. Okay, well, thank you. Tell your office staff thank you for all their help.
No problem.
Board
right.
members, thank you.
Thank you.
It will be
Thank
on
you.
the website
Thank you.
soon. All right, thank you.
All right, have a good evening.
You too, hon.
Good
Bye-bye.
night.